PSI does a really good job listing them, but sometimes they don't put a full explanation. So I appreciate the confusion that has resulted here with defense. Now for offense variable 12, which we know is MCL 777.421, we see that it's 3 or more contemporaneous felonious criminal acts involving crimes against a person were committed. And that scores for 25 points. And again, why is there confusion? Because underneath MCL 777.43, which is offense variable 13, it reads almost identically. It says the offense was a pattern of felonious criminal activity involving 3 or more crimes against a person. However, we know that you have to read further as to what that span of time is, and it's not necessarily written in that one spot or box. So the board agrees that offense variable 13 is scored improperly, and it should read as, I don't think there were any other offenses, were there? Yeah, because there weren't 3 or more felonies.
No, Your Honor.
Yeah, so that will be scored at 0. However, the court will score offense variable 12 and increase that from 0 to 25. So what we're doing basically is scoring OV12 at 25 points and adjusting the score for OV13 down to 0.
May I ask, Your Honor, are you making...
No, hold on. I'm sorry. There was a slight break. Just 1 second. Mr. Carnes, you were going to ask something?
No, Your Honor, I was agreeing. I agree that's appropriate scoring.
All right, Mr. Reddick, go ahead, sir.
I apologize for the overlap. Zoom makes it kind of hard.
If it's okay.
But I was going to ask, Your Honor, are you making that ruling sua sponte, or would you agree that the argument has been waived by the people not doubling down in essence in the brief on OB13?
Okay. What I think here is I agree that OB13 as you motion is correct. I'm sorry, your request is correct, that it should not have been scored at OB13. Now, what I understand the prosecution asking is for the court to move that 25 points over to OB12, correct?
That is what I'm asking orally today. I acknowledge I did not notice that when I was writing my written response, but I am asking for that in oral argument.
So the court, therefore, in effect, is granting the motion or oral motion today of the prosecution to increase OB12 from 0 to 25. So in effect, I'm granting both motions. Now,
may I ask if this will allow us a resentencing? I know.
Yes.
Then is a denied meeting. I didn't have agreement.
Hold on. What often happens with some of the correctional facilities, we can occasionally hear other cases, and I have no idea why. So, Mr. Ratner and Mr. Eiserman, it's very difficult. I don't know why it often happens in that particular prison. I see it all. I hear it all the time. So now I'm going to go back to you, Mr. Ratner. You were asking, will this allow for a resentencing? The answer is yes. However, if I recall correctly, you had another argument to make. And,
yes, sir.
And I'm going to note that if argument 2 was that the court erred considering the uncontested, I may have mentioned the pending charges. I don't find him guilty of it, and I don't really apply it much at all. If I did, I may have just said, and you still have other charges pending. So I would say that you are correct. I'm not supposed to, but I would say I didn't consider any pending charges. I might say it because I want to cover that I've gone over the entirety of the PSI, and there's one more box open. typically when I see at a PSI a pending charge, I generally ask if it's been resolved. I assume it wasn't at that time. If we go into a resentencing, which we're going to do, I'm going to ask Mr. Stapleton to look into that to find out if it was resolved, and if so, how. Which of course could be in the favor, of Mr. Eisman. So, all right.
If I may.
Yeah, of course.
So, I do know that this charge has not seen trial yet. It is still pending. I believe the trial is in September. We would like to have an evidentiary hearing on that before. I know that when I went over the sentencing transcript, if I may, on pages 15 through 16, I note that the court said, I can take judicial notice and make a finding based upon preponderance of the evidence of the factors that have resulted in his new charges over in Ludington. I'm not making a finding of guilt, but I am going to take it into consideration to some minimal degree.
So I understand. I did read that. So what I want to do now is I would take a look at whether or not somebody had told me that there had been some evidence to support it, or if it was included in the PSI. 1 second. Yes, Mr. Carnes?
There was a prior bond violation submitted to the court with the Ludington police report attached to it. And that's why I think the basis for finding by a preponderance of evidence was the court's review of the police report.
That would make sense. I generally do not consider anything pending unless I've received some evidence. So if I've made a finding of a preponderance, then it would be based upon that. Let me take a quick look here inside the file.
Process, maybe website can, we'll be working on that today. Well, take. Well.
Oh, all right. So I can see in the file that on January 26th, this court received a program violation report from our community corrections office. And attached to that was a writ for the habeas issued by this court. And let me see if there's any evidence to support it. There was a stipulation to revoke bond, am I right? I see. Yeah.
Facebook.
Well, if I could sit here rushing myself, I would want to take a look at in a little bit more particular fashion.
Okay.
May I clarify my argument just to kind of guide the court?
Yeah, you're fine. Go ahead.
So I know the people took issue to my analysis of People v. Grimmett. I used that case to, in its holding for not being able to assume guilt or make a finding of guilt. However, I think the case that I would rely on most in this argument is People v. Ewing. I know that defense counsel at trial had said, we plan on fighting these allegations to the end. He has maintained his innocence. My position is that should have informed the court that there needed to be an evidentiary hearing where someone could present actual evidence as opposed to relying on unsworn testimony on a police report. I think that, and I'm not asking the court to make a ruling on the extension of Beck. I wanted to preserve that on the record because I think that is important to raise going forward. However, what I am asking the court to do is, in granting the resentencing, allow us the opportunity to adequately challenge the allegations, which it did not look like Mr. Niagos did at the sentencing.
Well, I'm not going to hold a complete evidentiary hearing. I don't think that's what the law requires. All I have to, pursuant to Michigan Rule of Evidence 1101, is consider evidence, and I can make a finding based upon preponderance, which it appears that's what I did based upon what the parties had presented to me. So so really what I think you're arguing is ineffective assistance, that they didn't ask for an evidentiary hearing? Oh,
correct. People v. Ewing says that non-convicted conduct cannot be considered unless there is an adequate chance for the defendant to challenge those allegations before a finding without an evidentiary hearing. My position is that relying on just the police report without the evidentiary hearing is akin to a finding, an assumption of guilt based on People v. Grimmett. However, I believe this could be cured by allowing the defendant an adequate chance to contest the allegations.
so did he not have one before? Or did he just not do it through his counsel?
It does not look like the counsel asked for an evidentiary hearing, allowed a way for the charges to be allow for the charges to be challenged in court before consideration. And I think that's important.
All right, well, what I'll do here is I will allow the case to have a resentencing date that will allow the prosecution to either recall a witness or maybe like the victim. If there's another victim impact statement, I can hear that again, or another one. I don't know. That makes sense, Mr. Carr? So if we're going to do a resentencing, that means that each side is going to get a second bite at the apple. Right?
Yep.
And so you can make another victim impact statement or have one made. And
Victim in this case, or are you talking about the pending matter?
I'm
in Mason
sorry.
County?
Wasn't this case a DV or a strangulation?
This was yes, Your Honor.
Yeah. So there would be a victim, right?
Yes, Your Honor.
There we go.
In this
So a victim can make a victim impact statement. That's what I mean.
Okay, yes.
So regardless of whether one was made before, you still have the right to present, and the victim still has the right to be heard again.
Understood.
So what I'm trying to say is you get the full second bite at the apple. Now, at that hearing, Mr. Ratner can also then challenge the court considering the police report. And he must present to me that he has a right to a type of hearing where he calls witnesses. Or that one of these cases, because what the cases that he's references, I understand, do not say what the adequate challenge will look like. So I don't think I need to have a little mini trial on the other case in Ludington.
That's my understanding. I wonder, can I get the site for People v. Ewing? Because when I type in the numbers listed in appellate counsel's brief, I am not pulling up People v. Ewing.
Oh.
Well, we're going to let you guys figure that out on your own time.
Fair enough.
Because what you can also do is just do Westlaw search with the language, right? Even if you don't have the proper case citation. Aha! I've been around, been doing this for 30 years. So, okay, here we go. Mr. Radner, don't worry about it. You guys can figure it out. Everybody has typos, not a big deal.
Yes, Your Honor, thank you.
Now, the next thing here is I will have my staff set it for another sentencing hearing. And the court will issue a writ to have Mr. Eisenman brought here to the court for that hearing unless he waives it. Now, sometimes people might be surprised that not all people at the Department of Corrections want the free trip driving and looking at the countryside, but you may want it. Some don't because they don't want to miss a class. For instance, if they miss a rehab class, a counseling program, does that impact their points and stuff like that? I will issue the writ anyways, and if Mr. Ratner, you find out from speaking with your client off the record today that he is willing to waive it, just put it in writing and we'll go ahead and sign it. I don't particularly care. It's the right of the defendant to be present here before the court at the time of sentencing. All right, folks. Madam Clerk, did you create a little order? Or, all right, Madam Clerk will take an order that creates, drafts all that, and we'll see you sometime whenever my secretary says be here.
Thank you, Your
Thank you
Honor.
so much, Your Honor.
All right, thank you very much. We are adjourned.